Hello and welcome to our estate planning masterclass on enduring powers of attorney and advance health directives. So this is a series of webinars that Estate First lawyers have put together for our valued financial advisor and accountant referring partners. And also if you're an advisor, we hope you enjoy it and you have some real take homes out of it. I'm going to introduce you to our speakers for today, and they are both long-serving lawyers with Estate First and dedicated estate planning lawyers. The first one is Lucy Marsden, who is a senior associate with us and has had many years' experience in estate planning. Lucy.
Thanks, Anne. Hello, everybody. Great to be here. Hope you're all keeping well.
Thank you, Lucy. And Lucy will be taking us through our first case study. We're going to do this webinar in 2 case studies. And so Lucy will do the first case study, which will be spouses selecting each other as substitute decision makers. Our second case study will be ably handled by Ella Evans, who is another estate planning lawyer with the firm. Say hello, Ella.
Hello, Anne. Thanks, Anne, and hello, everybody. Great to be here, and thank you for watching.
Awesome. So Ella is going to take us through case study number 2, which is where you don't select your spouse as the substitute decision maker. Perhaps you are a widow or you just are single, and the scenarios that play out when you select an adult child or more than one as a substitute decision maker. Okay, so let's get started. And I've now given you an overview of what the webinar is going to be, and we have 1 hour for this webinar. So 2 case studies is our overview. Now, I'm going to take you through just very quickly the purposes of our training. So Estate First is known for its training of advisors, and we always try and make it practical, obviously informative, and hopefully a bit entertaining too. But our 3 purposes which we strive to achieve in these webinars for you is the first one, of course, is that you will actually have the content and the information. So knowledge is power, and it's power to help your clients. It also gives you confidence. So when you're having those estate planning conversations with your client, you have got a reasonable understanding of the topic. Purpose number 2 is my favorite purpose, and that is you can have a whole head full of content, and yet when you are faced with a client saying, well, I have an enduring power of attorney and it's up to date, how do you respond? How do you go deeper? How do you connect the dots or create the bridge into a deeper conversation? And that's what we will be doing in this webinar in relation to enduring powers of attorney and advance health directives. And purpose number 3, of course, is very, very important. And that is you want to act in the best interests of your client. You want to give them this information that is relevant for them, create the awareness in them of what they need in the estate planning realm. But what you don't want to do is slip into legal advice. So you don't want to go past what your advisory license requires. And so a quick rule of thumb is if you're starting to provide a legal solution, you've probably gone too far. But certainly if you provide legal information and it is relevant to the client's circumstance, you've done them a big favour. So that's the 3 purposes of this training. All right, just a quick word about Estate First. For many of you, you'll be well known to us and will be well known to you. We are an estate planning dedicated law firm, one of the only ones in Australia to do that. And we have 6 estate planning lawyers on the team. We provide an Australia-wide service. So whilst this webinar is on enduring powers of attorney and advance health directives in Queensland, we can do enduring powers of attorney and the care planning documents for your client in any state or territory of Australia. So, all right, that's enough about us. I'm going to give you a very quick COVID update on the law in Queensland. Now, as you may know, New South Wales brought in laws in terms of virtual signing and virtual witnessing for wills and enduring powers of attorney and enduring documents generally in New South Wales back in April. But in May, on the 15th of May, Queensland brought in their own legislation in relation to virtual witnessing of wills and enduring powers of attorney, as well as advanced health directives. So in Queensland, as in all states of Australia, you need 2 witnesses for a will. This allows you to witness a will virtually. So if you're watching your client sign the will document over Zoom, for example, in real time, then you can be a witness. The requirements are onerous. So one of the witnesses must be a special witness, and a special witness includes lawyers, JPs and Comdex. And there is quite a set of stringent requirements that need to be fulfilled by the special witness and a Section 21 certificate issued for each document signed in that way. So it is, whilst the government's to be commended for bringing it in, it is quite a lengthy and expensive process to do. We can certainly do it, but stick to the traditional way if at all possible. Okay, now, so just a quick disclaimer before we start on our case studies. The content of this webinar is obviously general. Because they're case studies, we have picked 2 specific examples that would be very common to your clients. But if your client, for any client that you have, they really need to have specific legal advice, and we'd be more than happy to help them. Okay, I'm going to hand over to Lucy, who is going to take us through the foundations of enduring powers of attorney and advanced health directives, and then take us through case study 1. Over to you, Lucy.
Thanks very much, Anne, and thanks for the introduction. Thought we'd kick off with something a little bit light. So for those of you who are parents, as a working mum of 2 primary school age children, I've been juggling working from home and the online learning, and I was pretty happy that the kids are back at school. And I promise, part of my disclaimer, I haven't taped the children up. So when we look at incapacity documents, there are documents in place that deal with what happens in the event of loss of capacity. These are done through an enduring power of attorney and also through an advanced health directive. There are also documents, of course, that are important if you are no longer living and pass away, and the administration of the estate becomes more important. And those documents involve the will, superannuation death benefit nominations, dealing with joint assets and how they pass, whether by survivorship, and control of family trusts. So today we will look at incapacity and the relevant documents. So firstly, what is an enduring power of attorney? An enduring power of attorney is the document to provide who is to make decisions for you if ever due to illness or incapacity or injury, you're unable to make decisions for yourself. So it's a legal document to make documents on someone else's behalf. And it is really important for every adult to have a valid enduring power of attorney in place. It's not just for the elderly. Capacity, of course, can occur at any age. So there's 2 main terms that are prominent in an enduring power of attorney. The first one is the principal. Now, a principal under an enduring power of attorney means the person who appoints an attorney to make decisions on that person's behalf. That is, the person who appoints. The second key term is the attorney. And the attorney under an enduring power of attorney is the person authorised to make decisions on behalf of another person. That is, the authorised decision maker. Now, enduring powers of attorney cover both personal health affairs as well as financial matters. And you do have the ability to designate different attorneys for appointments for each. The personal health decisions involve those relating to Personal health care, deciding who to make decisions if you're no longer able to make decisions about your own health care. Alternative care arrangements, daily living decisions, right down to those end of scale decisions, for example, turning off a life support system. Financial matters involve those relating to from as simple as paying bills, dealing with bank accounts, selling a property. In relation to the enduring power of attorney, you also have the ability to decide when the financial power commences. For personal health matters, power only commences on incapacity, and whilst you have capacity, you'll make all your own personal health decisions. There is ability for the financial power to commence immediately, and that can have the convenience of not needing to prove incapacity, which can be difficult to prove. Now, if you don't have a valid enduring power of attorney in place and you lose capacity, there is a risk that government bodies will then need to manage your affairs or force family members to apply to QCAT in Queensland to be able to look after you and your affairs. And QCAT appointments are by far more restrictive and erroneous. Now, it's very true, enduring powers of attorney forms can be downloaded in their shell form from the internet. And prepared by the principal themselves. But an enduring power of attorney prepared by a layperson or somebody not experienced in estate planning will not address some really important issues. Okay, and it really is crucial to get it right at the onset. Once loss of capacity does occur, it simply is too late to get that document properly prepared. Now, authority to act is under an enduring power of attorney document, okay? So for the authority for the attorney to act for the principal is governed by the actual enduring power of attorney document. And it is subject to the Powers of Attorney Act of Queensland, with each state and territory having its own laws and legislation. The Powers of Attorney legislation is of course aimed at protecting the person with the impaired capacity. And it primarily does this by placing restrictions, default restrictions, on the attorney when they're engaging in transactions on behalf of the principal. Now, when we look at these default restrictions or the attorney's obligations, these include firstly the attorney being required to keep their property separate from that of the principal's. For example, if the attorney has had to arrange sale of the principal's principal place of residence because they've lost capacity and moved into a nursing home, then the attorney, of course, must keep the proceeds of sale in the principal's bank account and not transfer those funds into their own bank account. Of course, where husband and wife are acting for each other and they do have joint assets, joint bank accounts, for example, there's not a requirement for the attorney and principal to separate those joint accounts. The second big key obligation for an attorney is in relation to the attorney acting with reasonable diligence to protect the principal's interest. Okay, there is a strict duty to always act in best interests of the principal and protect the principal's interest because they are the vulnerable person. And the third main obligation is the duty to avoid conflict transactions. It prohibits the attorney from engaging in a transaction that could involve a conflict of interest. And they can only engage in that conflict of interest transaction if it has been expressly authorised by the principal. Now, the default rules in the legislation often prove unworkable in circumstances where close family members are acting for each other, husband and wife, or children for a parent. And it's critical that the enduring power of attorney does include special terms and conditions to cater for the principal's particular circumstances, give them flexibility to deal with the financial changes that could occur into the future, and also family dynamics. So what are these conflict transactions and terms, and what does it all mean? Now, under the relevant legislation, an attorney for financial matters may enter into a conflict transaction only if the principal has expressly authorised them to do so. So we need the express authorisation in the enduring power of attorney document. Now, a conflict transaction is any transaction where the interests of the attorney or the interests of a family member or friend or business associate of the attorney may conflict with that of the principal. So the attorney must always act in the best interest of the principal unless they have been expressly authorised. Now, husbands and wives are often on the same page when they're making financial decisions throughout the course of their marriage and their lifetime. However, once one loses capacity, things can change. People look at things differently, and there could be a little bit of arm wrestling or back and forth between them, where one person's interests could conflict with the other, and that's sometimes where we see problems arise. So the second document to look at today is for loss of capacity is the Advanced Health Directive. What is an Advanced Health Directive? Now, it is the other document that is relevant in loss of capacity, and it is a separate legal document that sets out your directions regarding future healthcare for various medical conditions. For example, what you'd like done if certain things occurred, setting out various medical treatments that you do or do not want, things that may lengthen your life or improve its quality at the end. For example, if you're in terminal illness phase. You're able to decide whether you want, for example, ventilation, hydration, treatment of antibiotics, right down to end of scale life decisions and turning off the life support system. Now, the directions in the Advanced Health Directive do override the personal health attorney's power to make decisions on those matters. So it takes precedence over the personal health decision on those particular matters that have been noted. Now, a good way to go through the enduring power of attorney requirements and the importance of a properly drafted power of attorney is through, I think, a case study. So let's have a look at our family here, okay? It's a single family unit. Bruce is 69 years old. He has recently retired as a public servant. He's happily married to wife Kathy. Kathy's a little bit younger, she's 61. Kathy's still working, she's a part-time teacher. She enjoys work still, and she'll continue for a couple more years. They do have 3 children of their union. Eldest son Michael, who is 35 years of age. Michael's a school teacher. He followed in mum's footsteps and went into teaching. And he's married with 3 children. Their middle child, Jane, is 31. Jane's an artist, free spirit, pretty casual with life, and she's happy, she's married, and she's just had her first child. And Bruce and Kathy's youngest is Bianca. Bianca's 24, she's a nurse, and she's just recently got married. Now it's important that we have a look at Bruce and Kathy's assets. Now they have their principal place of residence at Camp Hill, which they own jointly as joint tenants. Knowing that when couples do hold their property as joint tenants, that property will automatically pass by survivorship rights. The property is valued at approximately $700,000. They have an investment property. The investment property is in Bruce's name. It was done for negative gearing reasons at the time. He was a higher income earner. And that does have a mortgage against it of $100,000. They have joint bank accounts totaling $100,000, and Bruce also has a sole bank account of $55,000. They both have superannuation. Bruce's super is now in pension income mode, and his balance is $450,000. Kathy's still in accumulation. She's still working for another couple of years, and she's got a balance of $350,000. And her aim is to try to bring her super up to the same balance as Bruce's, and she'll keep working. Now, as advisors, Bruce and Kathy come on board, and you're doing your fact find with them and completing the initial documents. And as part of that process, you ask the question, do they have enduring powers of attorney in place? Kathy and Bruce answer quickly, and yes, of course, we have done our enduring powers of attorney. We've selected each other in the first instance, and then the children as our backup attorneys. And as their advisor, you tick the box and you leave it at that. You've covered off. Now, over the years, a few years later, sadly, Bruce suffers a stroke, okay, and he loses capacity. Kathy, as your client, now comes to see you for some financial advice. And she needs some advice, firstly, around the investment mix of hers and Bruce's superannuation fund. And she also wants to obtain some personal financial advice. And she makes an appointment to come to see you. Now, you'll recall that Bruce appointed Kathy under his enduring power of attorney as his attorney for personal health and financial matters. And remembering he's just got a standard enduring power of attorney in place that does not contain any special terms and conditions. Now, Kathy comes to see you and she wants to do a few things. Okay, so first of all, she wants to review her and Bruce's super investments, okay, and potentially make some changes. You know, is it right that they're 80% growth, 20% balanced? She also wants to simplify life. She wants to consider paying off her credit card. She feels it's also time to upgrade and buy a new car. And she's also considering withdrawing funds from their joint bank account and contributing it to her super account. Now, as the advisor, you start questioning. Now, can she actually do these things that she intends to do, that she wants to do? Does she have the required authority? Can she simply implement the repayment of debts or the purchase of the new car through Bruce's super or through his sole bank account? So that makes you start thinking as the advisor, what can she actually do? Can she deal with Bruce's assets just because she's his spouse, or does she need that authority? Okay, so that authority, what is actually needed? So let's explore that further. So first of all, what is Kathy actually allowed to do or authorised to do under Bruce's enduring power of attorney? Now let's look at each one individually. The first one that Kathy wants to undertake is she wants to authorise you as her advisor to change Bruce's investment mix in his superannuation account. Now, whether or not that's a good thing or not, we're not looking at the financial investment decision. We're looking to see whether or not there is authority for her to undertake that. So under that power of attorney, she has the ability to make financial decisions for him. So I think the answer there would be yes. She does have the authority under the standard enduring power of attorney to make decisions for Bruce regarding the investment mix of super. Now, our second question, second thing Kathy wants to do is, can she use the joint funds, the 100,000 in the joint bank account, to make a contribution into her own super account? Can she do this? Now this is tricky. On the surface of it, we might say, look, yeah, it's joint cash. Can she do it? But certain arrangements are strictly off limits if it's been prepared under a simple enduring power of attorney. Because remember, any financial transaction where the interests of the principal could conflict with the interests of the attorney, so Bruce's interest as a joint bank holder with Kathy's interest to put it into her super account, could conflict. Now, where there is that conflict, remember there must be an express authority to allow her to enter into that transaction, and she doesn't have that express authority. So no, she's not able to do that under the existing document because of the conflict. The third one, Kathy wants to buy a new car in her name, and she wants to withdraw money from Bruce's sole bank account. So again, is Kathy authorised to make this transaction? Can she withdraw funds out of Bruce's bank account to buy a new car in her name? Now this one's, I guess, not as cut and dry, okay? It's on the first surface of it, without any conflict transaction allowed or authorisation, we'd say no. But there is another aspect to spouses acting for each other, or attorneys acting and being able to provide funds to dependents. Now, an attorney is authorised to provide for the reasonable needs and maintenance of the principal's dependent. Now, Kathy, being Bruce's dependent, it could be that she would be able to then, under this standard document, to purchase that vehicle, but it's a little grey. Yeah, a little grey. And what do you think?
It's an interesting one, and I'm always a little bit anxious when clients come to me and I know that their spouse has lost capacity or is well on the way to losing capacity. And I start to look feverishly to see if the terms are there that allow us to freely but still, correctly deal with the diminished capacity person's assets. And I would tend to say that buying the car, as long as the car was a reasonably ordinary car, would be okay, given that Kathy is his spouse and therefore a dependent. But if she was going out to buy the new, Mercedes-Benz, I'd say she's overstepped the mark there. And so really it does come down to what the client wanted in the first place, the one who's got diminished capacity, what they would have envisaged happening, and they often don't go there in their mind. So it's really important. This document is so restrictive between spouses that I would go so far as to say standard form is never going to be adequate in terms of spouses being substitute decision makers for themselves. But I won't steal your thunder, Lucy.
No, I totally agree. Thanks, Anne. Now, the last thing Kathy comes to you and wants to do is that credit card debt. It's been troubling her and she wants to pay it off. And she's querying, can she withdraw the money from Bruce's bank account to settle that credit card debt? Now, again, clearly a conflict. So we'd say no. Her debt to pay off with Bruce's funds will be a conflict of interest, and she's not authorised to do it under that standard enduring power of attorney document. So if we look back, say, to that initial conversation that we had with Bruce and Kathy when they first came on board as your clients, what maybe could we have done differently to maybe assist with this situation? As advisors, I think it's really important to dig a little bit deeper. And instead of simply asking, do you have an enduring power of attorney in place or who do you appoint, maybe actually go further and actually ask, are there any additional terms in your enduring power of attorney? Or was it just the standard form? Unfortunately, most of the enduring powers of attorney that we see come across our desk or that we're reviewing in the meetings will be the standard document. And it really is vital that those terms and conditions are included, particularly as our population is aging, and giving them the flexibility to deal with their affairs as required. So we can see that it really comes down to the quality of the document, and if it doesn't include those drafted clauses, it won't work adequately and it can't really be relied upon later. So we can see that there are real clear deficiencies between the standard EPA and the tailored EPA, which includes the special terms and conditions. And by including those special terms and conditions, Kathy would have been able to do all those things, changes Bruce's super mix and the investment strategy, pay off the credit card, buy the new car, and contribute to her super. Very straightforward once authorization is given. So let's just finally look at some red flags for advisors and some important things for you to keep in mind when you have spouses making decisions for each other under an enduring power of attorney. Firstly, be really careful who is instructing you. There has to be some authorization from your client to allow the person to be telling you what to do. Okay, and remembering that authorization comes from the enduring power of attorney document. And just be careful that you are taking advice from someone who is authorized to deal with those assets. Secondly, spouses need the enduring power of attorney to make financial decisions for each other once loss of capacity occurs. Okay, and again, without a properly drafted enduring power of attorney, Kathy's hands were tied when she came to see you because she didn't have the authority, the power to do the things that she needed to do with Bruce's assets. So just make sure that you are acting on the correct person's instructions. And finally, so important to ensure that you're not leaving your estate planning documents, the client's estate planning documents, too late. The enduring power of attorney needs to be carefully thought through, carefully drafted to include the relevant terms and conditions relevant to each family's own personal circumstances, and also giving them flexibility to deal with their assets. So go that little step further, ask the question, Does it contain those special terms and conditions? So that's I guess wrapped up case study one of between attorneys and spouses. Ella's now going to have a look at children acting as attorneys, and she's going to illustrate this through case study number 2. Thanks, Ella.
Thanks so much for that, Lucy, and thank you all for watching. Nice to be here. I just thought I'd start with this little image here, which, look, I'm sure many of us can relate to. Certainly pulling into January, start of the new year, new decade, I'm sure we all had big plans and the best intentions, but unfortunately coronavirus had other ideas by the looks of things. And here we all are just making the best of a bad situation. So as Lucy mentioned, what I am going to focus on today is really looking at the second level of life. So looking at some issues that can arise where we have a parent that's appointing children to act under an enduring power of attorney document. In particular, I'm really going to focus on certain transactions that Kathy may still wish to enter into with her children. That now might have some issues that get raised due to the fact that now the children are no longer just considered her children, they are considered Kathy's attorneys. And with that, as Lucy very well mentioned, comes certain strict responsibilities and duties. For example, the duty not to enter into conflict transactions when acting as Kathy's attorneys, the duty to act with reasonable diligence, etc. So just talking through some issues that can arise there and really fleshing out how that might play out in practice. So you'll see there in case study 2 now, it's a little bit few years down the track, and unfortunately Bruce has passed away. Okay, Kathy's a little bit older now, she's 76, still got the 3 children, Michael, Jane and Bianca. You can see there that Michael has now unfortunately gone through a divorce, so he's fallen on some hard times in terms of his own personal circumstances. In terms of Kathy's assets, rather similar to before in that now everything's owned solely in Kathy's name following Bruce's passing. She's still got the residence at Camp Hill, still with the investment property nice and close by at Mount Gravatt, bank account in her name, 2 superannuation accounts, and the good news is that she's now without any debts or liabilities, which I'm sure we can all agree is a pretty good place to be, certainly at someone at Kathy's sort of age. So Kathy meets with you for a financial review after Bruce's passing. So she's still one of your very valued ongoing clients, and she still comes to you for financial advice over the years. And during that meeting, you ask Kathy about her enduring power of attorney. And she says that she still has the old one that she made when Bruce was still alive. Now, as financial advisors or professional advisors for clients, you can certainly dig a little deeper than that to certainly, extract some further information from Kathy to see where things are at currently. A really good suggested response, just to dig a little deeper, might be saying something like, now that Bruce has passed, who will control your financial as well as your personal and health affairs? Did Kathy appoint backup attorneys to act in the event that Bruce was no longer here? And if so, who did she appoint? So really just drilling down into it a little bit further, rather than just simply ticking the box, yes, she has an enduring power of attorney, actually delving into whether that document does need to be updated now that Bruce has passed. And certainly just from a practical point of view, we often see clients where their spouse has passed away, and the enduring power of attorney is often one of the very last documents that gets looked at. So most clients are aware that yes, they have to change their will, but the enduring power of attorney can fall by the wayside a little bit without some further prompting. So really important document to update as well when a spouse does pass away.
And Ella, it can be beneficial too, can't it? Because if the spouse is still noted as that first appointed attorney, and then the children are the backups, the substitute, they're having to maybe provide a copy of the death certificate each time they're needing to do a transaction. So a review is really important if a spouse has passed away.
Absolutely, Lisa, that's exactly right. Otherwise, it can become very impractical to utilise that document. So certainly a good idea to freshen it up just to make it as user-friendly as possible for the children. Yep, that's a really good point. So let's say now that Kathy says, yes, she has updated her enduring power of attorney document now that Bruce has passed. and that her enduring power of attorney document appoints the 3 children to act on her behalf. And we say, okay, great, she's doing well. But again, is there some further questions that you might ask Kathy at that point in time, just to dig a little bit deeper? And we say that yes, there certainly is questions that you could ask. And a good suggested response might be, okay, how did the children act on your behalf? You know, do they act severally, jointly, for example? And I'll talk you through the differences shortly. So really getting, you know, a bit more of an understanding about how that document might work in practice, as well as also asking whether that document, you know, was it professionally drawn? And what I mean by that was it the document that was printed out off the website, completed by Kathy herself in front of a justice at the peace, for example, or was it professionally drawn with an experienced estate planning solicitor that has a lot of experience in these types of documents? So really getting into what the quality of the document itself might be. Certainly where we meet with clients like Kathy who are appointing their children, it might be because their spouse has passed away, or they might be single, for example, and they're looking at appointing the children directly. One very important consideration for Kathy is going to be how she wants her children to make decisions on her behalf. So how her children will act under the document. And it's particularly relevant where there's multiple children, particularly where there's, say, 3 or more children. And Kathy has some options available to her. The first option might be that she wants the children to act jointly on her behalf. So she wants them all to make unanimous decisions. And sometimes we have clients where, you know, this is definitely what they want to occur. They want it to be unanimous across the board. A consideration there might be, though, looking at the practical issues of that. For example, Kathy's got 3 children. You know, is it going to be practical for them to make unanimous decisions on her behalf? What if one of them's living interstate or overseas, for example? So sort of looking at the practical issues that may arise there. Another option Kathy might want to consider is potentially appointing the children to act severally on her behalf. And that means that any of the children can act on her behalf sort of independently of one another. So yes, it doesn't require unanimous decisions, so it's a bit more perhaps user-friendly in that respect, but it does come with certain risks is in that it does, you know, raise the risk of one of those children perhaps going rogue behind their siblings' back and acting in a way that's untoward to Kathy's interests under the document. So another option that Kathy might want to consider is looking at appointing her children to act as a majority on her behalf. Now, where we've got 3 children acting by majority, that of course means that any 2 of the 3 would need to act unanimously on Kathy's behalf. 2 out of the 3 might be a bit more practical and user-friendly than requiring 3 unanimous decisions. But, you know, there might be a better protection of interests there for Kathy because 2 heads are better than 1 sometimes. There's not really a right or wrong answer here. It's really going to depend on what Kathy's preferences are, whether she, you know, favours flexibility or whether she favours requiring unanimous decisions and so on. So it's just more saying that we would talk her through her options and the pros and cons of the options and help her reach an informed decision. As Lucy mentioned as well, certainly in Queensland and in some other states as well, you can separate out the appointment for the financial type of decisions and the personal and health type of decisions. So looking at the facts here, you know, Bianca is a nurse. Kathy might feel more comfortable with her acting in terms of the personal and health type of decisions, such as consenting to operations and treatment, etc. But she might want some of the children acting by a majority in relation to the financial affairs, just so there's a bit more of a check and balance there. So she has a lot of options available to her. Lucy also mentioned as well that in relation to the power for the personal and health type of decisions, in Queensland, those powers only begin if Kathy was to lose capacity to make those types of decisions herself. And she can specify for the financial power whether she wants that to commence immediately or perhaps at a later date, such as on her loss of capacity. So certainly we often find that where clients are appointing their children, perhaps in the first instance, they might be a little bit more inclined to appoint the children to make financial decisions on their behalf if they've lost capacity to make those decisions themselves. Whereas, as Lucy mentioned before, sometimes where you're appointing the spouse in the first instance, it might be a bit more practical to have that financial power commence immediately. So again, there's not a right or wrong answer there. It's just talking the clients through their options and the practical implications of those choices. So what I sort of wanted to touch on now is some issues that can arise with Kathy choosing to enter into some financial transactions with the children now that she, has decided to appoint them under the enduring power of attorney document. So Kathy says yes, she has updated the document and she has appointed the 3 children to act on her behalf as a 2/3 majority. So she's off to a great start there. Michael, as we mentioned, is now going through a divorce and unfortunately he's lost his job and is unemployed. He's therefore living in the investment property that Kathy owns in her sole name. Okay. While he's living at the investment property, he's been a great help to Kathy. So he helps out around, goes to visit her, helps her out with the lawn maintenance, etc. Helps her out around the home, drives her to appointments and so on. Given that he's fallen on some hard times financially, Kathy's allowing him to live in the property rent-free, but he does pay rates and electricity, insurance premiums, and so on and so forth. In terms of Kathy, she is a bit more mentally, she's a bit more physically frail rather than when you've been meeting with her in the past. She has had a couple of falls, but mentally she's still quite sharp as a tack. So no issues there about Kathy's mental capacity. So Kathy's doing a bit of future planning in terms of her own financial circumstances, and she's received advice from a financial advisor who just so happens to be a friend of Michael, that it might be a good idea for her to think about gifting away some of her assets now in order to maximise pension entitlements in the future and potentially minimise any government care fees that may apply down the track when she does need to move into aged care. So looking towards the future, let's just say. So Michael's come up with a great solution. He says, look, Mum, why don't you just transfer the property to me? You can gift me the investment property. Okay, after all, he's already living there. He's gotten quite comfortable there. That's where Michael's sort of rebuilding his new life. Keep in mind that Michael is one of Kathy's attorneys under her enduring power of attorney document. However, Kathy does still have mental capacity, so the power itself has not yet come into play. Okay, because under Kathy's enduring power of attorney document, the power for financial decisions only begins if she's lost capacity to make those types of decisions herself. Kathy's convinced that yes, she does want to transfer the property to Michael and she wants that to be a gift. So she's ready to sign the transfer documents then and there. So we need to look at, well, is this something that Kathy can legally do? Okay, yes, she has capacity. She wants to gift the property to her children. Is this within her sort of means to do that? And the answer to that is definitely yes. Okay, this is something that Kathy can do as a consenting adult with legal capacity. However, what we need to consider is that while Kathy can transfer the property to Michael, there is a risk that that transaction is later set aside due to this concept of what we call undue influence, which is a real sleeper issue in circumstances like this. Where we have a transaction between a principal, in this case Kathy, and an attorney, in this case Michael, that very fact automatically creates a legal presumption that Michael has somehow unduly influenced Kathy to enter into that transaction. So he's unduly influenced Kathy to transfer the property to him as a gift. Now, importantly, that presumption applies regardless of whether Michael did in fact influence Kathy or not. Okay, it's presumed to have applied due to the very fact that it's between a principal and an attorney. Even more importantly, that presumption applies regardless of the fact that Kathy still has legal capacity. Okay, so even though Michael's not yet acting under her enduring power of attorney document, the presumption still exists that he in some way influenced his mother to transfer that property to him. So that's going to become a real issue for Michael if Jane and Bianca ever raise the issue in court down the track. The reason being that if they raise that issue, It's then up to Michael to prove that the undue influence has not occurred. Okay, so it's not up to Jane and Bianca to prove that it has. It's up to Michael to prove that it has not, because the undue influence is already presumed. So that's going to be quite a high burden for Michael to overcome, particularly without any evidence supporting it either way. So for that reason, where we have a client that does want to make quite a large, gift or transfer to a child who may be an attorney under an enduring power of attorney document, it's very vital that both of those parties to that transaction obtain independent legal advice. Okay, so they both need to be advised of their rights and responsibilities and obligations so that they can both make an informed decision on an independent arm's length basis. And that would be needed in order to, that would assist Michael with properly rebutting that presumption if his sisters did raise it in court.
Yes, this is an area of growing concern, and as advisors, you should be watching out for this, because some parents are wanting to transfer property to their children. It might be because they have plenty of money in retirement and they just want to see their children enjoy some of their wealth that they don't need. But sometimes it is due to perhaps pressure being put on the client, the elderly client, by one or more adult children who need the money because they are in a totally different age bracket with financial needs such as mortgages and school fees and so on. So it's definitely something to watch out for. And Ella, I'm really glad that you brought this topic up. It's not good enough either for Michael, and also like just protecting Michael if in fact this transaction is totally above board. He might say, well, I resign as attorney before the transaction happens, and therefore there's no presumption of undue influence. However, what we're seeing is that his siblings, after mum passes away, are tending to look at transactions that happened before she passed away, perhaps when she was more elderly and frail, and trying to claw back the assets that she gave away before she passed away. So getting independent legal advice is obviously one of the best ways of rebutting a legal presumption. And I would be saying to Michael to do that irrespective of whether he's an attorney or not.
That's exactly right, Anne. I would completely agree. And this type of issue has come before the courts sort of time and time again as well. So it's definitely a live issue out there in society. So really important to be aware of, absolutely. Look, another point that Kathy should always consider as well, of course, is what the estate planning implications of that gift to Michael might be. So keep in mind that Kathy's will, in all likelihood, could leave all of her estate equally to her 3 children. But now Michael's getting quite a large windfall during his lifetime. So, he's getting the $600,000 investment property as a gift, which is really going to throw out what his sisters might be receiving under the estate. And we need to think about whether that's what Kathy actually intends. So making sure that Kathy gets estate planning advice about the implications of that gift, and that would be a really good opportunity perhaps to recommend to Kathy that she obtain that advice just so she can consider the estate planning implications. There's a whole range of estate planning, solutions that we could implement for Kathy, perhaps to adjust what her daughters will be receiving under the will, to account for that gift to Michael. It's really going to depend on what her sort of intentions are. Now let's look at the example where Kathy has now lost capacity. So again, a few years down the track, she has lost capacity and she's looking to move into a nursing home. It has come to that sort of time. Keep in mind that Michael was residing in that investment property rent-free prior to Kathy's incapacity. We need to look at whether that current arrangement can continue. Okay, and under Kathy's standard enduring power of attorney document, the answer is no, because that would be considered a conflict transaction in that Michael's interests are conflicting with those of Kathy's as the principal. Now, some of you may be wondering whether the circumstance might be different, or whether the outcome might be different rather, if Michael pays market rent for living in that property. And again, under Kathy's standard enduring power of attorney document, the answer is still no, that would not be permitted, because even though he's paying rent at the market rate, it's still considered a conflict transaction because it has the potential for Michael's interests to conflict with those of Kathy's. Okay, so it still wouldn't be allowed. Let's look at Jane and Bianca now, and that they're looking to sell Kathy's home in order to cover the nursing bond at her care facility. And we need to look at whether that's something that they can in fact do under the standard enduring power of attorney document. And in this case, the answer is yes. Okay, there's no possibility there for, you know, their interest to conflict with those of Kathy's if they're selling the house to a third party for full market value, for example. And that's certainly within their realms to do as an attorney under the enduring power of attorney document. Now, this last sort of circumstance has come up in a few cases. And again, what we're looking at here is if the nursing bond is less than the sale proceeds. So Jane and Bianca have sold Kathy's house, they've covered the nursing bond, and there's some excess sale proceeds. And they say, look, we're the three beneficiaries under the will. Why don't we just transfer it to all of us in equal shares? After all, we're going to be receiving it once Kathy passes away anyway. Some attorneys, you know, out there in the real world think this might be okay. At law, unfortunately, no, that would not be a permitted transaction. So remember, if Kathy had come to see us, we would certainly have talked her through all of these issues. We would have asked her what it was that she intended to achieve, what type of transactions she wanted to allow or exclude, for example, and we would have made sure that those sorts of terms were in the document. Remember, it's not just a matter of what Kathy intends, it's a matter of what the law itself says and how that interacts with the enduring power of attorney document itself. So really important to get that thorough estate planning advice. Now, when we do meet with clients like Kathy, these are some examples of some terms that we may recommend including in the document. The first would be, well, do we want to authorise the attorneys to enter into conflict transactions on Kathy's behalf? And we may say that they can enter into those transactions provided it's in Kathy's best interests. So that might allow, for example, Michael to continue residing in the property provided he pays rent at the market rate. It might even allow Michael to purchase the investment property for market value, for example. If that's in Kathy's best interest, those sorts of transactions might be authorised under the document. Certainly where we have a client that has a child that's already living in a property that they own, we often include clauses in that document allowing those current arrangements to continue so that Michael would still have the ability to reside in that property rent-free, even if Kathy loses capacity, if that's what Kathy would have intended. Okay, and we make sure that it's subject to that property needing to be rented out or sold to fund Kathy's care needs, because her needs must always take precedence over the needs of Michael. We need to think about superannuation as well in the context of the enduring power of attorney document and also in the context of the overall estate plan. So where appropriate, we may recommend including clauses in there allowing the attorneys to make withdrawals from superannuation on behalf of the principal, and also potentially allowing the attorneys to renew any existing binding death benefit nominations in relation to those superannuation policies as well. Now, those terms are subject to what the rules of the particular funds allow, but those rules often change over time, so we make sure that those clauses are in there if it fits the client's intentions, so that their intentions are quite clear in that respect. Now, those clauses should never be looked at in isolation, particularly where super is a very important part of the estate plan. Now, in terms of the Advanced Health Directive document, as Lucy mentioned, this allows you to sort of make your own end-of-life treatment decisions. And it can be very beneficial where you have a client that's appointing their children, because it can just give them peace of mind knowing they're carrying out mum or dad's wishes rather than calling the shots at an already sort of, emotionally charged kind of time. It does need to be completed with a medical practitioner, and it needs to be witnessed by either a justice of the peace or a lawyer. So certainly where we're assisting clients with these types of documents, we make sure that it's completed appropriately every step of the way, and always important to review it regularly as the client's wishes may change over time as well. I thought I'd just touch as well on when to register an enduring power of attorney document. So clients often ask, when does it need to be registered? And really it only needs to be registered with the Land Titles Office in Queensland if they're wanting to deal with certain property held by the principal. So that might be something like selling the principal's home. It might be registering or releasing a mortgage and so on. So it's a matter of registering that with the Land Titles Office. It does incur a registration fee of about $192, but very important to do before the attorney is actually authorised to act. Just looking at Queensland as well, currently Queensland's the only state where it's possible to actually upload a copy of the enduring power of attorney documents itself and the Advance Health Directive documents to an electronic hospital record. And that's done through the Office of Advanced Care Planning, which is funded by Queensland Health. And that can be accessed by health practitioners on behalf of the clients, etc. There's no charge to register, but it's a good way of having all the documents there in an electronic sort of database that can be accessed by the doctors, for example, in the event of a medical emergency, let's just say. So quite a useful offering there by the Queensland government. So thank you for listening, everybody. I think I'll just hand over to Anne now to wrap things up for us. Thank you very much for your time.
Thank you, Ella. That was excellent. And I think we've learnt quite a bit there. Just quickly in closing, I just wanted to show you the very cool things that we have built on our website for advisors. It's called the Advisor Hub, and there are some very good advisor tools. They're all free for you to access. You can just jump on the estatefirst.com.au website, go to Advisor Hub, and then go to Advisor Tools. And there you will see a broad range of things. I'd like to just show you some of the fact sheets that we have developed. There's quite a lot of them there, and they go into some depth on the topic. So if you want to have a refresher on a particular subject, or you want to send one of these fact sheets to your clients to read, certainly the fact sheet on testamentary trusts and wills is extremely popular. Then please feel free to go on the website and do that. We also have a range of videos. There is a video called A Will Is Not Enough that you can also share with your clients for those who just need a little bit more information about estate planning and why they can't just do a 2-page will. And we've also got our brochures, estate planning booklet. We have a number of flyers like a red flags flyer, estate planning health check. So many tools for you to freely download for yourselves or for your clients. So please go and take a look and feel free to access those things. Now, in terms of contacting us, if after you've seen this webinar, you would like to ask a question or get clarification on an area, it doesn't even have to be on enduring powers of attorney, advanced health directives, it can be on anything that's estate planning, then you are most welcome to contact myself, Lucy, or Ella. If you have a client query, we are happy to look at it for you, obligation free, just to give you some initial guidelines on that. And certainly we would love to meet you and have a chat about how we can possibly help you and your clients in the future, because we are committed and dedicated estate planning lawyers. So thank you very much for joining us and listening in on this webinar. If you have any feedback on the webinar, we would also love to hear from you. So I'm just going to hand it over to Lucy to say goodbye.
Thanks, everybody. Thanks for listening and take care.
And Ella.
Thanks, everyone. Thank you so much for your time.
And we'll see you for our next webinar, which will be coming soon. Okay, take care.